Health and Safety Code 11350 makes it a crime to have possession of a controlled substance. Now, when we think about possession, we think about having it on your person. So it being in your pocket or your purse or holding it in your hand. But actually, under California law, the legal definition of possession is a lot broader than that. It can include actual possession or what the law calls constructive possession. Constructive possession is when you don't actually have it on your person, but you have control over it or a right to exercise control over it. So, for example, if it's at your house or in the desk at your office or in a storage bin somewhere where you're keeping it, and you're not necessarily there at the time. I mean, take, for example, a situation where I have drugs at my house in Los Angeles, and I'm in San Francisco, 400 miles away. The police go and find the drugs. Even though I'm far away from the drugs at the time, nevertheless, I have a right to assert control over them, and they belong to me, and I'm aware of their presence, and therefore I could be charged with possession. Now, simple possession of a controlled substance, and this can be heroin, cocaine, methamphetamine, ecstasy, simple possession is a misdemeanor. And that changed under Proposition 47, which passed in November 2014. Before Prop 47, it could be charged as a felony, and as a felony carried up to 3 years in jail or prison. But now, under Proposition 47, it's only a misdemeanor and only carries a maximum sentence of 1 year in county jail. Now, in spite of only being a misdemeanor, there's still a lot of consequences to being convicted. Like I said, there is a maximum sentence of 1 year in county jail. Moreover, it looks really bad on your record. Most employers will shy away from an applicant who's been convicted of a drug offense out of fear that they have a drug problem and they would be a liability in the workplace. So to the extent that you're charged with possession of a controlled substance, you want to do everything that you can to fight the charge and keep it off your record. Here at Schaus Law Group, we've had a lot of success in helping our clients do just that. It may be that the police discovered the drugs by way of an illegal search or seizure. Maybe they searched you without a warrant or without probable cause. It may be that the drugs didn't even belong to you. Maybe they were found in the trunk of a car you were driving, but it may be that several people drove that car or several people had access to it, and the DA ultimately can't prove who the drugs really belong to. And even in a situation where it's crystal clear that you did have possession of a controlled substance, we can almost always get you into a diversion program under Proposition 36 or PC 1000, where you do a class, and if you complete it successfully, then the charge gets dismissed and you don't go to jail and ultimately does not go down on your record.